Hello and welcome back to the Daily Facts. This is part 10 and the final part of the Sidney Powell, Georgia lawsuit. So let's get right into it. The widespread pattern, as reflected within the population of unreturned ballots analyzed by Dr. Briggs, reveals the unavoidable reality that, in addition to the calculations herein, third parties voted an untold number of unlawfully acquired absentee or mail in ballots, which would not be in the database of unreturned ballots analyzed here. See OGCA 21 2 522. These unlawfully voted ballots prohibited properly registered persons from voting and reveal a pattern of widespread fraud. Further, there exists clear evidence of 20,311 absentee or early voters in Georgia that voted while registered as having moved out of state. Specifically, these persons were showing on the National Change of Address Database, NCOA, as having moved or as having filed subsequent voter registration in another state, also as evidence that they moved and even potentially voted in another state. The 20,311 votes by persons documented as having moved exceeds the margin by which Donald Trump lost the election by 7,641 votes. Plaintiffs expert Russell Ramsland concludes that at least 96,600 mail-in ballots were fraudulently cast. He further concludes that up to 136,098 ballots were illegally counted as a result of improper manipulation of the Dominion software, Ramsland affidavit. The very existence of absentee mail-in ballots created a heightened opportunity for fraud. The population of unreturned ballots analyzed by William Briggs, PhD, reveals the probability that a far greater number of mail ballots were requested by third parties or sent erroneously to persons and voted fraudulently, undetected by a failed system of signature verification. The recipients may have voted in the name of another person, may have not had the legal right to vote and voted anyway, or may have not received the ballot at the proper address and then found that they were unable to vote at the polls except provisionally due to a ballot outstanding in their name. When we consider the harm of these uncounted votes and ballots not ordered by the voters themselves, and the potential that many of these unordered ballots may in fact have been improperly voted and also prevented proper voting at the polls, the mail ballot system has clearly failed in the state of Georgia and did so on a large scale and widespread basis. The size of the voting failures, whether accidental or intentional, are multiples larger than the margin of votes between the presidential candidates in the state. For these reasons, Georgia cannot reasonably rely on the results of the mail vote. The right to vote includes not just the right to cast a ballot, but also the right to have it fairly counted if it is legally cast. The right to vote is infringed if a vote is canceled or diluted by a fraudulent or illegal vote, including without limitation when a single person votes multiple times. The Supreme Court of the United States has made this clear in case after case. CEG Gray versus Sanders. Every vote must be protected from the diluting effect of illegal ballots. Crawford versus Marion County election. There is no question about the legitimacy or importance of the state's interest in counting only the votes of eligible voters. Reynolds versus Sims. Plaintiffs have no adequate remedy at law, as seen from the expert analysis of William A. Higgs, PhD, based on actual voter data. Tens of thousands of votes did not count, and tens of thousands of votes were unlawfully requested. The 14th Amendment Due Process Clause protects the right to vote from conduct by state officials which seriously undermines the fundamental fairness of the electoral process. Marks versus Stinson and Griffin versus Burns. Separate from the Equal Protection Clause, the 14th Amendment's Due Process Clause protects the fundamental right to vote against the disfranchisement of a state electorate. Duncan versus Poitras. When an election process reaches the point of patent and fundamental unfairness, there is a due process violation. Florida State Conference of NAACP versus Browning. If the election process itself reaches the point of patent and fundamental unfairness, a violation of the Due Process Clause may be indicated and relief under 1983, therefore, in order. Marks versus Stinson, enjoining winning state Senate candidate from exercising official authority where absentee ballots were obtained and cast illegally. Part of court's justification for such a ruling is the Supreme Court's recognition that the right to vote and to free and fair elections is one that is preservative of other basic civil and political rights. See Black 209F Sup 2D at 900, quoting Reynolds 377 U.S. at 56-2. Since the right to exercise a franchise in a free and unimpaired manner is preservative of other basic civil and political rights, an alleged infringement of the right of citizens to vote must be carefully and meticulously scrutinized. See also Yick Wo versus Hopkins. The political franchise of voting is regarded as a fundamental political right because preservative of all rights. The right to vote, the right to have one's vote counted, and the right to have one's vote given equal weight are basic and fundamental constitutional rights incorporated in the Due Process Clause of the 14th Amendment to the Constitution of the United States. Black 209F Sup 2D at 900, a state law that allows local election officials to impose different voting schemes upon some portions of the electorate and not others, violates due process. Just as the Equal Protection Clause of the 14th Amendment prohibits state officials from improperly diluting the right to vote, the Due Process Clause of the 14th Amendment forbids state officials from unlawfully eliminating that fundamental right. Duncan 657 2D at 704. Having once granted the right to vote on equal terms, defendants may not, by later arbitrary and disparate treatment, value one person's vote over that of another. Bush 531 U.S. at 104-05. In statewide and federal elections conducted in the state of Georgia, including without limitation the November 3rd, 2020 general election, all candidates, political parties, and voters, including without limitation plaintiffs, have a vested interest in being present and having meaningful access to observe and monitor the electoral process to ensure that it is properly administered in every election district and otherwise free, fair, and transparent. Moreover, through its provisions involving watchers and representatives, the Georgia Election Code ensures that all candidates and political parties, including without limitation plaintiff, Republicans, and the Trump campaign, shall be present and have meaningful access to observe and monitor the electoral process to ensure that it is properly administered in every election district and otherwise free, fair, and transparent. Defendants have a duty to guard against deprivation of the right to vote through the dilution of validly cast ballots by ballot fraud or election tampering. Rather than heeding these mandates and duties, defendants arbitrarily and capriciously denied the Trump campaign and Republicans meaningful access to observe and monitor the electoral process by A, mandating that representatives at the pre-canvass and canvass of all absentee and mail-in ballots by Georgia barred attorneys or qualified registered electors of the county in which they sought to observe and monitor, and B, not allowing watchers and representatives to visibly see and review all envelopes containing official absentee and mail-in ballots either at the time or before they were opened and or when such ballots were counted and recorded. Instead, defendants refused to credential all of the Trump campaign submitted watchers and representatives and or kept Trump campaign watchers and representatives by security and metal barricades from the areas where the inspection, opening, and counting of absentee and mail-in ballots were taking place. The lack of meaningful access with actual access to see the ballots invited further fraud and cast doubt on the validity of the proceedings. Consequently, defendants created a system whereby it was physically impossible for the candidates and political parties to view the ballots and verify that illegally cast ballots were not opened and counted. Defendants intentionally and or arbitrarily and capriciously denied plaintiffs access to and or obstructed actual observation and monitoring of the absentee and mail-in ballots being pre-canvassed and canvassed by defendants and included the unlawfully not counting and including uncounted mail ballots, and they failed to follow absentee ballot requirements when thousands of voters received ballots that they never requested. Defendants have acted and will continue to act under color of state law to violate the right to vote and due process as secured by the 14th Amendment of the United States Constitution. Plaintiffs have no adequate remedy at law and will suffer serious and irreparable harm unless the injunctive relief requested herein is granted. When we consider the harm of these uncounted votes and ballots not ordered by the voters themselves, and the potential that many of these unordered ballots may in fact have been improperly voted and also prevented proper voting at the polls, the mail ballot system has clearly failed in the state of Georgia and did so on a large scale and widespread basis. The size of the voting failures, whether accidental or intentional, are multiples larger than the margin in the state. For these reasons, Georgia cannot reasonably rely on the results of the mail vote. Relief sought is the elimination of the mail ballots from counting in the 2020 election. Alternatively, the presidential electors for the state of Georgia should be disqualified from counting toward the 2020 election. The United States Code 3 U.S.C. 5 provides that if any state shall have provided by laws enacted prior to the day fixed for the appointment of the electors for its final determination of any controversy or contest concerning the appointment of all or any of the electors of such state by judicial or other methods or procedures, and such determination shall have been made at least 6 days before the time fixed for the meeting of the electors, such determination may, pursuant to such law so existing on said day and made at least 6 days prior to said time of meeting of the electors, shall be conclusive and shall govern in the counting of the electoral votes as provided in the Constitution and as hereinafter regulated so far as the ascertainment of the electors appointed by such state is concerned. 3 U.S.C.S. 5. Request for relief. Accordingly, plaintiffs seek an emergency order instructing defendants to decertify the results of the general election for the office of president. In an alternative, plaintiffs seek an emergency order prohibiting defendants from including in any certified results from the general election the tabulation of absentee and mail-in ballots which do not comply with the election code, including without limitation the tabulation of absentee and mail-in ballots. Trump campaign watchers were prevented from observing or based on the tabulation of invalidity cast absentee and mail-in ballots which lack a secrecy envelope or contain on that envelope any text, mark, or symbol which reveals the elector's identity, political affiliation, or candidate preference do not include on the outside envelope a completed declaration that is dated and signed by elector or are delivered in person by third parties or non-disabled voters. When we consider the harm of these uncounted votes and ballots not ordered by the voters themselves and the potential that many of these unordered ballots may in fact have been improperly voted and also prevented proper voting at the polls, the mail ballot system has clearly failed in the state of Georgia and did so on a large scale and widespread basis. The size of the voting failures, whether accidental or intentional, are multiples larger than the margin in the state. For these reasons, Georgia cannot reasonably rely on the results of the mail vote. Rather sought is the elimination of the mail ballots from counting in the 2020 election. Alternatively, the electors for the state of Georgia should be disqualified from counting toward the 2020 election. Alternatively, the electors of the state of Georgia should be directed to vote for President Donald Trump. For these reasons, plaintiff asks the court to enter a judgment in their favor and provide the following emergency relief. 1. An order directing Governor Kemp, Secretary Raffensperger, and the Georgia State Board of Elections to decertify the election results. 2. An order enjoining Governor Kemp from transmitting the currently certified election results to the Electoral College. 3. An order requiring Governor Kemp to transmit certified election results that state that President Donald Trump is the winner of the election. 4. An immediate order to impound all the voting machines and software in Georgia for expert inspection by the plaintiffs. 5. In order that no votes received or tabulated by machines that were not certified as required by federal and state law be counted. 6. A declaratory judgment declaring that Georgia Secretary of State Rule 183-1-14-0.9-15 violates the Electors and Elections Clause, U.S. Constitution, Article 1, Paragraph 4. A declaratory judgment declaring that Georgia's failed system of signature verification violates the Electors and Elections Clause by working a de facto abolition of the signature verification requirement. 8. A declaratory judgment declaring that current certified election results violates the Due Process Clause, U.S. Constitution, Amendment 14. A declaratory judgment declaring that mail-in and absentee ballot fraud must be remedied with a full manual recount or statistically valid sampling that properly verifies the signatures of absentee ballot envelopes and that invalidates the certified results if the recount or sampling analysis shows a sufficient number of ineligible absentee ballots were counted. 10. An emergency declaratory judgment that voting machines be seized and impounded immediately for a forensic audit by plaintiffs expects. A declaratory judgment declaring absentee ballot fraud occurred in violation of constitutional rights, election laws, and under state law. 12. A permanent injunction prohibiting the governor and secretary of state from transmitting the currently certified results to the Electoral College based on the overwhelming evidence of election tampering. 13. Immediate production of 36 hours of security camera recording of all rooms used in the voting process at State Farm Arena in Fulton, Georgia, from 12 a.m. to 3 a.m. until 6 p.m. on November 3rd. 14. Plaintiffs further request the court grant such other reliefs as is just and proper, including but not limited to the cost of this action and their reasonable attorney fees and expenses pursuant to 42 U.S.C. 1988. Respectfully submitted this 25th day of November 2020. All right, that is going to conclude the read through of the Sidney Powell, Georgia lawsuit. Thank you so much for stopping by the Daily Facts. And please do like, share, and leave a comment below. And we'll talk again very soon. You take good care. Bye.